Adam Schiff sits down, opens the file, and goes straight for the throat. Did Emil Bove really tell the DOJ to ignore a federal judge? In seconds, Bove is stumbling, dodging, and pretending not to remember the one thing no one could ever forget.
Mr. Bove, I want to turn to the meeting that Mr. Ravaney, the whistleblower, has written an extensive complaint about. The hearing started with the chairman reading a social media post by the Deputy Attorney General Blanche, who is present today but not under oath, nor is that social media post under oath. So let me ask you, since you are under oath, in the complaint it says, Bove stated that DOJ would need to consider telling the courts, fuck you, and ignoring any such court order. Did you say anything of that kind in the meeting?
Senator, I have no recollection of saying anything of that kind. To the extent I
Wouldn't you recall, Mr. Bove, if you said or suggested during a meeting with Justice Department lawyers that maybe they should consider telling the court, fuck you? It seems to me that would be something you'd remember, unless that's the kind of thing you say frequently.
Well, I've certainly said things encouraging litigators at the department to fight hard for valid positions that we have to take in defense of our clients.
And have you frequently suggested that they say fuck you and ignore court orders? Is that also something you frequently do, such you might not remember doing it on this occasion?
No, and as I explained, I have never directed...
So did you or did you not make those comments during that meeting?
Which comments, Senator?
You really need me to repeat it? Did you suggest, as Mr. Ravaney wrote, that DOJ would need to consider telling the courts, fuck you, and ignore any such court order?
I did not suggest that there would be any need to consider ignoring court orders. At the point of that meeting, there were no court orders to discuss.
Well, did you suggest telling the courts, fuck you, in any manner?
I don't recall.
You just don't remember that. Well, let me ask you this. It also says in the complaint, Bove indicated and stressed to all in attendance that the planes needed to take off no matter what. These are the planes that a judge was ordering not be used to render people to a maximum security prison outside the country. Did you say during that meeting, did you stress to all in attendance that the planes needed to take off no matter what?
Senator, your characterization is not accurate.
It's not my characterization. It's the characterization of a decorated prosecutor who was in that meeting. Are you saying that he's lying?
As I said at the beginning of the hearing...
No, I'm not interested in what you said at the beginning of the hearing. I'm interested in whether you stressed to people in attendance that the planes needed to take off no matter what. Did you say that?
I certainly conveyed the importance of the upcoming operation.
Well, don't paraphrase here. Did you tell people in attendance the planes needed to take off no matter what?
I don't recall the specific words that I used.
Wouldn't you recall saying that if you had instructed that the planes needed to take off no matter what, including whether the court ordered otherwise? You wouldn't remember that?
This is a mischaracterization, Senator. There were no court orders at this point.
Well, there was a court order, wasn't there?
No,
wasn't there a court order by Judge Boasberg, if not in this specific case, then in related cases, that people not be sent out of the country until the court could rule? Wasn't there a court order?
Not at the time of that meeting, Senator.
Did you participate in the decision not to disseminate that oral court order prior to the written court order to other agencies so those planes would not take off, so those planes would turn around? Were you involved in the decision to withhold that court order from the responsible agencies?
I think it's clear that I participated in this.
Yes or no?
I participated in this matter, and I'm not going to get into the contents of legal advice. I did over the course of time, as many lawyers have.
No, I'm not interested in over the course of time. I'm interested in whether you participated in the willful violation of court orders as alleged in this complaint. Let me ask you this, Mr. Bove, if there are notes of that meeting, will you provide them to this committee?
I defer to the committee and to the executive branch on the procedure.
And if the committee requests them, will you provide those notes to the committee?
I defer to the executive branch on the handling of that request.
And let me ask you about notes from another meeting, which you're contesting here, and that is the meeting over the decision to dismiss the case in New York, the corruption case against the mayor of New York. According to Ms. Sassoon, the U.S. attorney at the time, during the meeting with Adam's attorneys, where she described Adam's attorneys repeatedly urging what amounted to a quid pro quo, that you admonished one of the lawyers in the room to stop taking notes. Is that true?
I don't believe I instructed that attorney to stop taking notes. I did remark on the fact that he was taking extensive notes, yes.
And why did it concern you that he was taking notes of that meeting?
Because at that point in the meeting, we were discussing who was responsible for media leaks, and I was making the point that only the prosecutors had created an extensive record that could support detailed leaks.
And you were concerned, were you, that information about this potential quid pro quo might become public? Was that the concern?
I've explained that there was no quid pro quo.
Will you provide the notes of that meeting, which you, according to the U.S. Attorney, instructed be collected at the end of the meeting?
I think a member of my staff may have given that instruction outside my presence, and I defer to the committee and the executive branch on records requests and how those should be handled.
Well, I would request that we seek these records, which go to the truthfulness or lack of truthfulness of this witness. There's a reason why, if I may, my colleagues have gone over at least as much as this. There must be a reason why prosecutors quit rather than following orders from you they considered unethical. There must be a reason why prosecutors complained about you in your own office, why defense attorneys complained about you in your own office, why the judge in the case involving the dismissal of the charges in New York said everything here smacks of a bargain. You testified earlier that the objective evidence overwhelmingly made it clear that it was not a bargain. That there must be a reason why everyone disagrees with you, Mr. Bove, and people feel it necessary to give up a job they love at the Department of Justice and quit because they won't go along with what they consider unethical and immoral orders from you. There must be a reason why that is so true of so many, and this court needs to get to the bottom of it. I yield back.
Thank you,
May I make
Senator
a parliamentary inquiry?
Go ahead, sir.
Thank you, Madam Chair. I've requested the notes from two pivotal meetings that go to the heart of the nominee's credibility. The meeting over the decision to drop charges against the mayor of New York, and the meeting in which the whistleblower alleges that the nominee suggested ignoring court orders and telling the courts essentially, fuck you. The witness has said that the decision whether to turn over those notes will determine or depend, I guess, on whether there's an assertion of privilege of some kind. And we have the great good fortune at this moment to have the Attorney General and the Deputy Attorney General here with us today. We can resolve this right now. I would ask through the chair whether the Attorney General and the Deputy Attorney General will approve the provision of these notes to the committee. They could be provided to the chair and the ranking member in camera if necessary, so that the question that Senator Kennedy asked about whether there was some illicit bargain and that my colleagues have asked can be resolved. If there are detailed notes of these meetings, it will give us an answer to who's telling the truth here. So I would ask the question through the chair of the witness, given we have the Attorney General and Deputy Attorney General here, will the Attorney General and Deputy Attorney General make these notes available to the committee so we can determine who's telling the truth here?
Senator Adam Schiff enters this hearing with the kind of calm that only comes from someone who has done this for decades, someone who understands the architecture of a cover-up, who knows how lies are built, and who has made a career out of dismantling them one question at a time. And as he speaks, you can feel that he has already read every email, every memo, every footnote of the whistleblower complaint at the center of this drama. He isn't guessing. He isn't probing blindly. He is walking into a room where he already knows the truth. He's simply testing whether Emil Bove is willing to say it out loud. And that's why Schiff begins with the most dangerous question possible for a nominee under oath. Did you say it? It sounds simple, but in a courtroom and in the United States Senate, did you say it is a loaded trigger. Because if the answer is yes, Bo admits to encouraging the Department of Justice to tell a federal court, fuck you, and ignore a lawful order. And if the answer is no, Bo is calling a decorated prosecutor a liar. Yet Bove chooses a third door, the coward's hallway of I don't recall. Now here's what viewers might miss if we don't unpack it. When a witness claims not to remember an extreme statement, that's not an answer. That's a strategy. Lawyers call it soft denial. It gives the witness space to retreat if evidence later surfaces, and that possibility is exactly what Schiff is circling around. He knows there might be notes. He knows people were in the room. He knows whistleblowers rarely walk into legal fire unless they are certain of what they heard. So Schiff presses him. How could anyone forget saying something so explosive, unless they say things like that all the time? This is where the human psychology becomes important. Schiff is not just interrogating facts, he's interrogating memory, credibility, pattern. And patterns are everything in government misconduct. They reveal whether a moment was a slip or standard operating procedure. And the more Schiff asks, the more Bove tries to balance on that tightrope. I encourage litigators to fight hard. I convey the importance of operations. I don't recall the specific words. These answers sound polished, but they're actually hollow. They avoid the core allegation that Bove allegedly pressured DOJ lawyers to launch flights even if court said stop, and possibly even to withhold a court order so those flights wouldn't be interrupted. And this is where Schiff deepens the trap. He brings up Judge Boasberg, a respected federal judge, known for being measured and neutral. Schiff points out that the court did issue an oral order restricting removals. Even if the written order hadn't yet arrived, the oral order should have been relayed immediately to every agency involved. That's how rule of law works. Court orders aren't optional. They don't have a waiting period. The moment a judge says stop, you stop. So Schiff asks Bove point blank, did you participate in withholding that order? And Bove, again, refuses to give a simple yes or no. He uses phrases like, I participated in this matter, but dodges whether he participated in violating a court order. That is not the language of innocence. That is the language of someone trained to stay inside the narrowest safe zone possible. Schiff sees it. He's seen it for years, in hearings from impeachment trials to intelligence briefings. So he shifts strategy. If Bove won't answer directly, then Schiff will expose the consequences. He brings up prosecutors quitting in protest, something that almost never happens. To understand the significance, DOJ prosecutors do not walk away from cases lightly. Their careers, reputations, and years of work are tied to the cases they take on. For multiple prosecutors to resign rather than follow Bove's direction means the internal alarms at DOJ were deafening. Schiff brings up defense attorneys complaining about Bove's conduct, extraordinary on its own, because defense attorneys typically benefit from DOJ missteps. If even they felt something was wrong, that's a red flag. He brings up the judge in the New York mayor corruption case, who said, everything here smacks of a bargain. Judges do not use language like that unless they believe the integrity of the legal process is in jeopardy. And Schiff connects all these separate episodes into one coherent narrative. There must be a reason so many people, from prosecutors to defense attorneys to judges to whistleblowers, have raised concerns about Emil Bove's ethics. This is the kind of narrative that makes a Senate hearing more than a hearing. It becomes an X-ray. Schiff is not just questioning Bove. He is showing viewers how institutional integrity erodes, not through one big scandal, but through many small moments that all point in the same direction. And that's why Schiff ends with the most important move of the entire exchange. He turns away from Bove.
He turns to the Attorney General and Deputy Attorney General, both physically sitting in the room, and he says, we can end this right now. Release the notes. Let the truth speak for itself. That is the moment everything shifts, because Schiff is no longer arguing about memory. He is arguing about evidence. If the DOJ releases the notes, we know who is telling the truth. If they don't, that silence becomes its own answer. And viewers should understand this part. Schiff is reminding everyone that the Senate's constitutional role is not ceremonial. It is investigative. It is part of the checks and balances designed to catch exactly this kind of conduct before someone is placed into power. So he asks again, will DOJ give the notes to the committee? The chair defers. Senator Durbin joins the request. The pressure multiplies. And the question hangs in the air. Is the truth being protected or concealed? And that brings us to the heart of this commentary. This hearing isn't just about one nominee. It's about the broader architecture of accountability. When courts issue orders, government officials must obey them. When whistleblowers risk everything, their testimony deserves scrutiny, not dismissal. When prosecutors resign en masse, that is a signal of ethical distress.
And when a Senate nominee can't remember whether he told the Department of Justice to ignore a federal judge, that's more than a red flag. That's the kind of moment that tests whether the public still believes in the rule of law. So here's the call to action. Pay attention, because transparency doesn't arrive on its own. It happens when the public demands it. If those notes come out, and they should, they'll answer the question Schiff posed with such calm devastation. Who is telling the truth? And what do you think? Did Schiff expose a pattern, or was Bove simply overwhelmed? Drop your thoughts below, because this story isn't finished yet, and the next chapter may depend on those notes finally seeing the light of day.